All right. Hello, everyone. Thank you so much for joining. Sherry, thank you for joining today.
You're welcome.
Yeah. So this update is going to be a little bit different than you might be seeing in the news or any other updates. We are going to give some immigration headline news updates in the fashion of Sherry's going to share with us what is happening, what does it mean, and then we're going to spend most of our time on what does it mean for healthcare organizations. So we're going to break this down. We know that immigration, there's a lot going on right now. And we also know that international or recruiting for internationally educated healthcare professionals is part of most hospitals' workforce plan to build stability, a way to bring in experience, and certainly, help with stability right now as organizations continue to focus on building future workforce. So Sherry, let's just start with the biggest headline that is going on right now, and that is the Massachusetts court case around the $100,000 fee. And before we get into that, I just want to comment again and remind leaders that H-1B is very different than other visas, and this only pertains to the H-1B. H-1B is typically in healthcare used for physicians, occupational therapists, physical therapists, nurses in specialty where the job description requires a bachelor's, and medical laboratory scientists. So this is one visa that we're talking about that sometimes goes broadly on this fee. So Sherry, can you walk us through what happened with the Massachusetts H-1B fee ruling, and what's the latest?
So that was a lawsuit that was brought by attorney generals from 20 different states, and they basically was arguing that the impact is significant, particularly for education and healthcare. Those are the two industries they focused on. So the court said that it basically that proclamation putting the $100,000 fee on it was essentially a tax. And because it was a tax, it was unlawful because only Congress can issue a tax. So what the court did is they vacated that proclamation, which basically is just a legal term saying that that proclamation is unlawful. So by vacating it, it's different than just an injunction from enforcing it. It's basically setting the entire law aside and saying this law cannot be enforced. And so that's where the court decided it and said it is unlawful to be enforced.
Okay, and what has happened since then? Share with us a little bit about the appeal, and the
Mhm.
temporary stay.
So USCIS didn't say anything initially. This was decided about, I guess, a week ago. It seems like much longer than that. USCIS didn't say anything initially. They have filed an appeal. The court has essentially paused the enforcement or basically pause their decision on determining that unlawful until this week. And then the USCIS will get to they file a motion for a stay. So
Okay.
essentially, there's two different issues. There's a filing of appeal of the decision, and then there's a temporary motion where a party can say, we want to have the court pause this decision and not move forward with this decision until after the appeals court decides the issue. So there's two things that would be happening. One, this appeal is going on, and a higher court will decide whether or not this judge got the decision right. And then there will also be contemporaneously with that a motion to basically put a pause or a stay on this court's decision until the appeals court decides it. So there could be a stay issue, which means that the fee's still in effect until the appeals court decides it. Or they could say, we're not going to issue a stay. And then in that case, we still have to wait for the appeals court, but USCIS could begin accepting cases without the fee until the court case is decided.
Okay, great. So as of right now, for any healthcare leaders out there, there is currently still $100,000 fee or tax that is associated with any H-1B filing. Is that right?
Correct. No, we're not filing H-1Bs yet. This is a positive sign that the door may open soon to be able to file, but right now it's status quo. You're not filing because you're going to have to pay the $100,000 fee. So right
Okay.
now we're waiting for what will happen, whether there's a stay on that, what will the Court of Appeals decide on that? And then there's two other cases that are pending on this issue. And then we also have the fact that the proclamation itself goes until September 21st of this year. And then we have an issue of whether or not it will just expire and not be renewed. So we have a couple of different options that may happen in the next couple of months.
Okay, great. So as of right now, still a fee. Hold off on filing at this point. And I think just the takeaways, one is that there's still a fee. The other takeaway is this $100,000 tax is unique to H-1B visas and not for every international pathway.
And I
But
think
certainly exciting.
the other takeaway is there is a victory here.
We will take the victory. There is a victory. And so I think it'll be interesting to see what happens with the ruling on the Chamber of Commerce. And we should be hearing that, I would think, within the next 30 days or so. And then there's the California case as well. So we'll continue to watch and provide updates. Also, a victory on the USCIS. So as long as we're talking victories, let's just keep going with it because that feels good. So tell us about the victory with USCIS.
Yeah, so another court in a different case decided that a couple of the USCIS policies or the administration's policies were not lawful. One of them being the hold on immigrant cases for certain nationalities, 39 different countries, based upon the country of nationality. So that court decided that USCIS pausing those cases was unlawful. Interestingly, on that one is that USCIS, I think they have filed an appeal on that. But what they also did is issued an announcement Friday saying that while they don't agree with the court's decision, they are going to abide by it and treat it as if the pause is not in effect anymore. So what that means is USCIS can start processing those applications that have been at USCIS and have been on hold. Some of those are adjustment of status applications. Some of those are applications for work authorization. Some are H-1Bs that have been paused. Some are employment authorization documents based upon I-485s. So USCIS will no longer just continue to pause those cases based upon country of nationality. Now, that doesn't mean they're going to get approved right away, because obviously there's some cases in the pipeline, but it means that that is no longer a basis to hold the case. They can go ahead and now, once it's in front of the officer can actually go forward and make a decision on that case.
So that is good news, and that is a victory. So for organizations, for hospitals or skilled nursing facilities, what might they? So they'll be able to see the transition, but is that students? That's individuals that are on an H-1B now?
Yeah, so the important thing to remember there is it doesn't have anything to do with the people that are outside of the US doing consular processing. This decision is strictly against the immigrant pause with USCIS. So it's only pertaining to those cases with USCIS. So people who had applications filed for maybe students, or people that were in H-4 status or dependent status that then filed for adjustment of status, those can actually start to see action now. So there may have been some employment authorization documents or even some H-1Bs that were held up based upon somebody's country of nationality. Those can proceed. It's not going to impact those that have the immigrant pause abroad. However, I will say there is another court case that's specifically against the Department of State along the same arguments and because of the same issue about it not being lawful to have a pause based upon a person's country of nationality. So this victory with USCIS, although it's limited to USCIS, gives us some encouragement that we may also see a victory on the Department of State cases, which means that those cases that are paused for maybe nurses that are outside the US from those countries affected could actually start to see their interviews being scheduled and immigrant visas issued.
Okay, fantastic. And thanks for expanding on that with what may be possible. So there's another USCIS update, and it's the adjustment of status memo. Kind of help
Mhm.
us understand that one and how it's different.
Yeah, so so if we're thinking about the immigrant pause, that pertained to who can actually proceed to getting their case approved.
Okay,
So it's all about who. When we talk about the adjustment of status policy manual update, that pertains to where. So basically, that policy manual about 3 weeks ago, USCIS just updated their policy manual that said adjustment of status should only be in extraordinary circumstances, it's discretionary. So, kind of created this concern in a lot of media reports about, USCIS no longer going to issue green cards, everybody has to leave the US. Technically, what it meant is just that last stage of the interview needed to be done,
right,
at the consulate. Didn't change the fact that even if you had somebody here as a student, they could still do the I-140 portion. They could still continue to work in the US if they had work authorization, but the interview would be scheduled abroad. So that certainly would be costly and inconvenient to have to
right,
travel abroad for an interview, be there for maybe 1 to 2 weeks, maybe longer if there's any delay at the consulate, having to do the medical exam. But it didn't mean that that was going to close off green cards. It just meant, where is that last step going to be done? Is it going to be done at USCIS with an officer in the US looking at the case? Or is it going to be done at the consulate in person with an interview with the case? So, that created concern, but it also was not reported accurately. That
okay,
was only pertaining to where that last step was. Since then, USCIS has backtracked and said there's really not been any change. This was just intended to inform the officers that they do have discretion and that, basically adjustment of status is a privilege, not a right, which it's
right,
always been that way. It's
sure.
always been a privilege, not a right. So I think practically what this means is it's still pretty much status quo with filing adjustment of status, but each case needs to be evaluated on its own because maybe there are circumstances where the person entered as a visitor and then is ready to soon file for adjustment of status. Those may be a little more risky because, there's always the issue that if you enter as a visitor saying that you're only coming temporarily and then you file for adjustment, then that's possible misrepresentation unless there's been some circumstances since you entered to change your mind. So I think it's going to be more case by case analysis. But for the typical cases where somebody's been on an H-1B, no status violations, not been in the US unlawfully, I think adjustment of status is going to continue just as normal.
Okay, so for healthcare leaders, not as much concern on the adjustment of status right now. It's going to be very typical. So the concern of having to have your internationally educated professionals go back to their country to do the consulate, that's not going to be there. But anybody on a tourist visa, that's going to be trickier, which it always has been. So like,
Yeah, or a
not
TN. A
or
TN's been
TN.
like that.
Yep.
Typically you come in as a nurse, you work on a TN, but you do your case for consular processing. When you get the
Right.
interview, you go back and you do it there and in
Right.
Canada. Yeah.
Okay, perfect. Thank you for clarifying that. All right, let's talk about because there's all these changes, but one of the visas that is used most often for nurses is the employment-based Category 3 visa. And the reason is H-1B, the requirement is the job description has to require a bachelor's. And so typically for hospitals, we see that for ICU or flow pool or emergency department, areas such as those. But others that do not require the bachelor's, nurses are coming through the employment-based category, and they're coming every month. We have over 100 coming in every month. So, I'd love to know, there's still sometimes things in the headlines on the delays and whatnot from a high level, just what is the employment based? And it's different than the H-1B and anything that you want to share that sometimes is in the news.
Yeah, so the employment-based route, whether you call it EB2 or EB3, those are just the different paths. EB2 is a position that requires at least a master's degree or a position that requires a bachelor's and 5 years of experience. EB3 is going to be something less than that as a requirement. EB3 is for everyone, every occupation, every employer, every educational level. The employment-based route can be used. It's just what tier are you on? What classification, depending upon the level of the job. So it's always going to remain an active path for everybody. And so that's why that's the most common used. Some people come in on an H-1B or a TN for temporary, because that's one of the first distinctions. One's temporary, one's permanent. But the other distinction is the employment-based route is open for everybody. As I said, every occupation, every nationality, every employer. Whereas some temporary options are based upon either occupation, which is like the TN category. There's 63 different professional occupations that are on the list. If you're not on the list, you don't qualify, whether you're a Mexican citizen or a Canadian citizen. There's also categories that are country specific, like the TN, which is Canadian or Mexican citizens, the E3, which is Australian citizens, and so forth. And then you have other categories that are education specific, where the H-1B requires at least a bachelor's degree. So whenever you're talking about categories that are limited by occupation or country or education criteria, you're going to have fewer people that qualify, which means you have less of a supply of candidates that are actually going to be eligible. And so that's why the employment-based route is the most widely used, because you can use it across any occupation, any country, any employer.
Right. And some of the delays or why it's taking longer has nothing to do with the visa pathway stability. It has everything to do with just the demand. There's a certain number of visas each year. The demand is high, and so that's what slowed down. With some of the country bans or country restrictions, that's impacted the visas. Maybe share with us a little bit about that and how what you think for fiscal year 2027 starting in October.
Yeah, so it doesn't change the fact that it's a viable pathway. It affects the timeline. And it can affect the timeline differently for different people. So if we're talking about the people that are affected by the immigrant pause, or the travel ban at the consulates, this has affected the timeline. Some of those that would have normally been able to get their visa and be in the US working are not able to do it because of the visa travel ban or the immigrant visa pause. It doesn't mean that they are not ultimately going to be able to come, it just affects their timeline. Same way with visa retrogression. Depending upon how the visa dates move, that may affect how long it's going to take before somebody arrives in the US. When we talk about the travel ban, interestingly, for some people, they're being delayed. For other countries, they're being helped by the travel ban because as the consulates are going through the issue of who's next in line, if it's somebody from a travel ban, they can't get their visa. So then they go to the next person that is available who isn't from an affected ban. So it's having a positive impact for people who are not affected by the travel ban and a negative impact for those who are. Interestingly, if you're talking about October, what we may see there is I think we're going to see some recapturing of numbers that are going to be unused from this fiscal year, particularly in the family-based category. Because if we look at the countries that are banned, they have a very high usage of family-based categories numbers in those from those countries. To the extent they haven't been able to issue visas for those this year, those numbers are going to go unused, which means that October 1st, they get to fall over from the employment to the employment-based category. So there's a 1 year fallover. If numbers are not used in the family category in 1 year, then the following year they fall over to the employment-based category, and then they're either used or lost in that following year. So I think this year we may see more positive movement for the countries that are not affected by the ban next year because of available numbers. And then once this travel ban is over for those countries that are in the employment-based category, we'll start to see those move forward and move on to arrival.
Okay, and that would be fantastic, and that's probably why we've seen some more movement this year in those categories. Anyways, here for leaders, here's how I would look at just your international pipeline. Everybody is looking at how to diversify your clinical pipeline. Individuals are doing, or hospitals and skilled nursing facilities are looking at new grads. They're looking at retention. They're looking at all these things, starting junior high and high school and building that future workforce, right? The same thing with international. You want to look at your different pipelines. The employment based is probably going to be your top one, especially for nurses. H-1B is so important because it gives an additional pipeline that can be a faster pathway for those that qualify. And then I'll just comment on the TN visa from Canada or Mexico. Also a great pathway, but the pool is not as great. It's less that are coming in with more employers looking for them. So I would say that is more like your supplement of bringing in individuals as well. But it's all kind of this very much a workforce strategy on understanding what the need is, which departments and what visa options are out there. So thank you, Sherry, for helping us understand that. And then we'll wrap up with just something that we are watching. So it's not final policy right now, but it's important for workforce planning, the proposed Department of Labor prevailing wage rule. Just at a high level, what should healthcare leaders understand about this proposal? And again, it is only a proposal at this point.
Yeah, so there's a prevailing wage requirement for EB3 permanent residence applications, so your nurses and everything in that category, plus certain other categories like the H-1B and the E3. With the Department of Labor, their public wage survey has 4 different levels. So what this proposal is to try to change the percentile of those levels so that what is currently level 2 will become level 1. So it's basically pushing all the wage levels up higher. So if the prevailing wage is now $30, it may become $33 as the minimum that you can pay for that. For some employers, that will mean nothing because they're already paying at higher levels anyway. For some people, that's going to be very hard to pay for, particularly rural areas, skilled nursing facilities, that kind of thing. That the data is only as accurate as the survey results that they get. So when they're getting a very narrow selection of employers that they're surveying from, those skew what those actual numbers are anyway. So sometimes we will see across not just healthcare, but other occupations where we look at the prevailing wage and employers will say, that's not really what employers in our industry are paying in this area. So sometimes they're just not right. So what this is designed to do is basically increase all of the wages up, and that could make it more difficult. I would say right now, what you want to do is basically consider that it's not in effect. It would apply to future applications. So, for example, if you have somebody that you're already doing the green card process for, whatever that prevailing wage is going to be what is applicable. So if you already have a case filed, that's not going to apply. It's going to apply to new cases. It might also not apply to all new cases if you already have a prevailing wage determination for that position in the occupation, then that one may be valid to be used until that is expired. Whenever they've done this in the past, you were able to use an existing labor condition application or prevailing wage determination if that's in effect. When this goes into law, if it does go into law, they may try to make it effective that you can no longer use an existing prevailing wage determination. That seems to be a little bit unlikely. First of all, that would be a lot of extra effort for Department of Labor to have to issue new prevailing wage determinations. So I don't think that they will make it applicable to all new. I think they will say if you have an existing prevailing wage determination or a labor condition application, that's going to be valid. So What you want to do there is err on the side that that's how they're going to implement it if they actually do implement it. And I would say make sure you have valid prevailing wage determinations in effect. Because if you get them issued now, anytime after July, they're good until next June 30th anyway. So I would say go ahead and get those in place just in case.
Yeah, and that's the recommendation we're giving too. If there's any, and regardless of if this goes through or if this doesn't go through, we always recommend keeping prevailing wage determination current. And the good news, let's do just another little good news is it used to take about 6 months. It's taken about 2.5, 3 months now to get back. So if there's any chance you'll do international recruiting over the next year, would definitely recommend that. So, Sherry, we covered a lot. I appreciate you jumping on and giving some of these updates. Internationally educated healthcare professionals remain part of most organizations' workforce stability plans, but it's really important that leaders understand which pathway fits with which role and which timeline, and to also make sure that some of the things that are in the news does not cover everything, especially on the $100,000. So, a few takeaways for leaders: EB3 remains the most widely used pathway for internationally educated nurses and very separate from the H-1B. Nurses continue to arrive each month. EB2 is a good option for physical therapists. Right now, the timelines are a little bit shorter, but that education has to be a master's. H-1B, we're going to continue to monitor and see what ends up happening with the Massachusetts case, but also monitoring Chamber of Commerce and the California case as well. But as of right now, the $100,000 tax is still applies. I would say the other TN can be very useful for eligible Canadian or Mexican citizens or professionals, but it's a smaller and more limited pool. So just having your expectations around that. Adjustment of status is still available, is going to require more case-by-case review in the United States, but not a whole lot of change. That kind of went back. The 39 country USCIS hold policy ruling may help some USCIS filed cases move. And when we say USCIS, it's in the United States. And Sherry, I'm sure you'll keep us up to date on the other potential legislation that would have that for those that are out of the country as well. And then Department of Labor prevailing wage rule, still a proposal, so nothing to worry about right now. However, if you are looking at recruiting or adding internationally educated healthcare professionals and direct placement, certainly something that you want to keep current. With that, if you have any questions, I know Sherry and I are always happy to have a conversation, or if you have a specific case, feel free to reach out to me and we can support with that. But Sherry, as always, appreciate you jumping on and just helping us understand these better.
Thank you, Car. You summarized all of that very well in the end. And
Woo!
as you were saying that, I was thinking, wow, a lot of that's just happened in the last month.
I know, and some of it just in the last week. And so
Yeah,
I'll
yeah,
leave with this. I'm hoping to see some more victories, Sherry, because I love when you say we've had a victory in, and I'm like, yay.
yeah,
All right.
yeah.
Well, thank you everybody for joining. Again, any questions, please reach out. If you have any questions, you can leave them in the comment and we will be answering those as well. Thanks again, Sherry.
Thanks, Cara.